Welcome, ladies and gentlemen, to this edition of the IPI High-Level Speaker Series. I have the pleasure of introducing to you the Honorable Moreno-Ocampo, who has served as the Prosecutor of the International Criminal Court for almost 9 years now. Mr. Moreno-Ocampo was elected as Prosecutor of the International Criminal Court in April 2003. From 1984 until 1992, as prosecutor in his native country, Argentina. He was involved in precedent-setting prosecutions of top military commanders for mass killings and other large-scale human rights abuses. From 1992 until his elections as prosecutor of the ICC, Mr. Moreno-Ocampo worked as a lawyer in a private law firm he established under the rubric Moreno-Ocampo and Wortman Geoffrey as a private inspector general for large companies. He also took on a number of pro bono activities, among them acting as legal representative for the victims in the extradition of former Nazi officer Erich Breivik to Italy, and participating in the trial of the chief of the Chilean secret police for murder of General Carlos Bratz, and several cases concerning political bribery, journalist protection, and freedom of expression. Honorable Ocampo has also been a visiting professor at both Stanford and Harvard universities. The relationship between peace and justice, the topic of today's conversation, is controversial. When an international legal body such as the International Criminal Court becomes involved in a situation of ongoing conflict, its work is often perceived as influencing political processes, if not the conflict itself. Arrest warrants and indictment of leaders that are party to the conflict change the incentive of the respective individuals to engage in peace negotiations, and therefore fighting might potentially be prolonged. Such were the allegations that were often heard after your office, Mr. Ocampo, sought arrest warrants for the senior leadership of the LRA in Uganda, and particularly after you talk on the President of Sudan, Omar al-Bashir, for his alleged role in the conflict in Darfur. Some critics accuse the ICC of directly and negatively affecting fragile peace processes. Yet, as time passes, perception of the court seems to be evolving. One of the most important relationships in this regard is that between the ICC and the United Nations Security Council. It is impossible to discuss the topic of peace and justice without acknowledging the complex relationship between these two international bodies. The Security Council has the primary responsibility for the maintenance of international peace and security. The ICC, in turn, is charged with ensuring an end to impunity for leaders that have committed atrocity crimes. And even though the UN and the ICC are formally independent, from one another, the UN Security Council has the ability to both refer cases to the ICC as well as suspend ICC prosecutions. The Security Council has twice referred cases to the ICC, the situation in Darfur and the situation in Libya, and has so far not made use of its power under Article 16 of the Rome Statute to defer the ICC prosecutions. The Rome Statute thus provides an important perimeter for the relationship between peace and justice, and for the relationship between the UN Security Council and the International Criminal Court. Before I give the floor to Mr. Moreno-Ocampo, please let me remind you that this event is public and on the record, and that we are webcasting this event live over the internet. Mr. Ocampo, we are delighted to hear from you, to hear your views on these topics, and the floor is yours.
Thank you. Thank you, Ambassador, so much for inviting me for this. I think it's a great opportunity to have a conversation. For me, it's interesting at the end of my tenure to have some reflections on these issues. The fact that we are talking about peace and justice is showing how primitive is the world. We don't talk about peace and justice in the domestic settings. We talk about justice and security eventually, but not about peace. Peace is consolidated in most of the national settings. But in the global setting, it's different. We have to discuss peace and justice. And in fact, what I'd like to discuss with you is first how innovative is this idea to have justice. This is totally new. 30 years ago, the idea was not there. So justice is a completely new idea, has less than 30 years. I would suggest less than 20 years, or maybe. And that is important to understand because peace has more time. Peace has, I would suggest, Westphalia, in fact, 1648, is an agreement what for the first time is the end of the 30 Years' War. And Westphalia is important because for the first time Westphalia agreements say will be a permanent peace. For the first time, humanity say will be a permanent peace. Before that, peace was a time between war and war. Peace and war were normally both. Westphalia is not the end of the wars, but it's the beginning of the idea we are establishing a permanent peace. And Westphalia is relevant because then all the treaties would follow for the following 2 centuries basically quote Westphalia. So, as you see, permanent peace is, in terms of humanity, is relatively new, has few centuries. And interestingly, the way to establish permanent peace was with military. So having a balance of power. If my neighbor had a big army, I had to also a big army. Of course, it was not a very stable system. And then you have diplomatic relations. And diplomacy was trying to achieve, through negotiation, permanent peace. After Kant, the world was also thinking in the idea to have a world federation, something like that. And in fact, when you read the speech of Theodore Roosevelt in 1910, when he received the Nobel Prize for Peace, Theodore Roosevelt, a US president, was proposing a global police to implement a global arbitration court instructions. Because they saw we need something bigger than national states, because this model of keeping balance of armies and negotiations would not work. And in fact, did not work. And you have the First World War. For me, it's interesting to see, I would suggest, Versailles Treaty, who established the League of Nations, was defined by Kant centuries ago, before, the Versailles is interesting because for the first time, they decided in Versailles that crimes committed were not just against one country. They considered the Kaiser committed crimes against the global community, the international community. And that's why Versailles Treaty requests to prosecute the Kaiser. As you know, it never happened because the Netherlands considered this crime was new and then was provided asylum. But it's interesting, Versailles was the first idea to have crimes committed not just against one country, committed against the international community. And then the League of Nations, with this agreement that whoever attacked one country would attack all the countries, did not work. And then we have the Second World War. And for me it's interesting because the League of Nations was the result of 2 centuries of thinking. Then, in some part, the failure, and the Second World War produced that Churchill and Roosevelt and Stalin were discussing a new model, with the current model, the UN security system. But they adopted Nuremberg, where this time they implement the idea. These people commit crimes against the international community, not just against Germans. And for Nuremberg has, for me, 3 different aspects. One is the first tribunal implemented the idea of international justice, but also, in particular, because Jackson, the prosecutor from US, proposed the idea that the crimes against peace, the aggression crime is the most serious crime, was the first time, and the last time, we have an aggression crime. And then they invented crimes against humanity too. And they connected, because crimes against humanity was against sovereignty. Because crimes against humanity is a government who is killing its own people, can be prosecuted internationally. And this is not connected with, it's complex, was different. But they say it's a crime against humanity as soon as connected with the aggression crime. So that's why for me Nuremberg was such a seminal precedent. But the world was not ready to transform this landmark into a permanent institution. And they had to wait, end of the Cold War, Balkans crimes, a new ad hoc pilot experience, then Rwanda genocide, a new ad hoc experience, and then 98, as you saw the video, the big change, a global call for the future, to prevent future crimes. And I like it, because when you see the history, you see how, it took 2 centuries to implement Kant's idea of League of Nations. Versailles influenced Nuremberg. Nuremberg influenced the Rome Treaty because aggression crime was included, but there is not yet agreement. Postponed the definition. 2010 we had the definition, but postponed the implementation. So it's still an ongoing process. However, the crimes are consolidated. The crimes against humanity, war crimes, genocide are consolidated, and we are applying that. And that's why at the beginning was just war, the both were peace, and now it's peace and justice. And the issue today, how we implement that. And my point today is this relation of peace and justice is maybe it's a complex relation because it's a primitive society. We are not talking about in the national setting. In the national setting, if my neighbor attacks my daughter and rape my daughter, we don't talk about peace. We talk it's a crime. And we don't think in wars. I don't go to kill him. I go to the judge and make it. So the institutional system helping us. And that's what happened today in the world. When when Afghanistan happened, when the Twin Towers happened, the world had not a permanent court to go. Now we have one. So we have options. And in fact, Libya is showing we can use the option. The issue is who's in charge of peace, who's in charge of justice? How much these 2 dimensions are connected? How much it's affecting the prosecutor office? And my point is, as the ambassador say, Security Council is in charge of peace. The ICC, and I like that he presents it's an international institution doing justice. And in some way, the prosecutor, who is the bridge between the court and the external world, I'm controlled by the court, the judges, in terms of the individual responsibility I'm attributing to some suspects. But the Security Council can control the court on peace. So a check and balance created by the Rome Statute are judges review the individual criminal responsibility. Security Council keep and retain the responsibility on peace. They can refer cases of countries who are not members of the treaty, but also they can defer any case because they have this responsibility of peace. And that's important to understand the role of the prosecutor. The prosecutor has no mandate on peace. And the prosecutor cannot change the evidence or the decisions thinking on peace, because then we'll destroy its mandate. The responsibility is Security Council. And that is, for me, the missing part. Because what happened since 2003 is that the court became in motion and is evolving. In fact, there was Article 16 resolution. When I started, 2003, there was an Article 16 resolution. Security Council distracted the court, and they passed a resolution, preventative, in order to keep the peacekeeper working because the US was refusing to participate if not. And in those days, I remember in the day of my screening, when I discussed it with my international relations advisor, I say, okay, the best idea to start a case will be with Security Council resolution, because I will connect peace and justice. And she say, forget it. You have 9 years? Impossible. It was impossible. But that's why I like to present the problem. The world changes so fast that the facts are much faster and different speed than the thinking. Because just 2 years later, after 3 months debate, 11 votes for abstention, there are full referral. And 2011, 1 day debate, 15 votes, consensus. So what is happening here? And that is, for me, the concept I like to use this opportunity to start the debate, to start to understand what is happening in the last years and how we have to adjust. And my comment is, the prosecutor has a duty to establish the law and to investigate the crimes. And interestingly, I present this because this map shows you in blue the countries who are members of the treaty today. I'm sorry, the video is talking about 117 and they say 119, and in fact today we're 120. So I would suggest there's a difference between blue countries and white countries or gray countries. Will be legally investigations in the blue countries. It's not clear this will happen in the gray countries. So that's the difference. We are living, when people talk about double standards, absolutely, we are living in a world with double standards. The blue country has one standard, the gray country has a different standard. However, I will suggest the following. The rule is the same. The rule is no leader can commit atrocities to gain power or retain power. That's the rule. If you, as a leader, commit atrocities to gain power, and you are in a blue country, you will face ICC. So the consequence will be political consequence in the world, but plus investigation and prosecutions. If you commit the same crimes in the gray countries, the Security Council will decide. And the Security Council decides case by case, in accordance with different, so the Security Council could decide in Libya, yes, and in Syria, we don't see the same. However, the rule is still there, because in Syria, in Yemen, the people in power are challenged because they are committing massive atrocities. And the Arab League, this year, or the last year, condemned Syria government for the crimes. So there is not a trial, but there is political considerations saying this could not happen. And Saudi Arabia was deeply involved in the Yemen conflict to say this could not happen. So what I see here is the rule is the same, the consequences are different. Will be automatically investigation and punishment in the blue countries. It's still more primitive in the white countries, where will be basically political debates. But now, ICC is an option. If they decide to do justice, ICC will do it. That's where we are. It's interesting for me because what I see, and I saw it in my tenure moving, is a new global order. Security Council was about big countries controlling the world. That was convenient in terms of contribute to not a big war again, who would be devastating. No one wants that. But as Argentinian, I can tell you, the Cold War was cold in the north, but pretty warm in the south. And I would say in Africa happened the same. So the Cold War produced conflicts. In my country, the guerrilla were trained by Cuba, the army were trained by French and US officers. So was a battle in the Cold War. But the Cold War also divided the world in terms of atrocities. You can even read today in the Kissinger book on China, the explanation he gave about why US and China were rational to stop Vietnam, what Vietnam was trying to stop the Khmer Rouge. So Khmer Rouge killed 2 million people, and US and China were stopping Vietnam for geopolitical reasons, not to stop that. So the Cold War was working for the big conflict, but was pretty bad for massacres in the South and in other places. And I think that's why, as soon as the Cold War ended, we have a difference in South America, difference in East Europe, and it's different in Africa. The world is changing. And basically what happened today, in particular after the experiment of Iraq war, no country, even the biggest country like this country, is willing to be involved in many conflicts. That means that now the national system and the regional system in particular has much more relevance. While Libya was referred to the court existed, that was good. Darfur existed, that was good. Gaddafi helped because had not a lot of friends. But was crucially important two aspects. The Arab League supporting the idea and Libyan ambassador supporting the idea. Then in this context, Security Council moved. So what we are not exploring enough, how this interaction between Security Council, regional organization, and national groups, sometimes not the official group, are now interchanging. And that is completely new, and you here, you are the actors. You are the ones managing this new world. But sometimes we are applying the recipes of the 50 years ago, who was a different world, totally different world. So we're in time of Facebook. We're in a new time. And then we have to see what should be different. My suggestion today is be basic. The basic is, first, peace is not the responsibility of the prosecutor. Prosecutor has a duty to do justice, and judges will review in accordance with criteria of law, no peace. So, Security Council in the gray countries can use the court as a threat to force the leaders who are committing crimes to negotiate. They can say, please, in this country, if you leaders are keep committing these crimes, we will discuss a referral to ICC. But if they refer the case to ICC, they have to understand they cannot keep this idea that, if you stop the crime, we unplug ICC. No. Yes, they can do Article 16, but don't expect the court following your plug and unplug ideas. If you like to unplug, go to Article 16. No other way. Because what I see is the court is a little piece of the new global system, and there's some confusion that the court has to establish peace. And in fact, if I try to adjust to the political negotiations, I will destroy my office. I should not do that. What I do, and that's something we learned in the beginning when we were discussing, when I took office, hundreds of people were asking me to intervene in Iraq. Iraq obviously was aggression crime, not my case. It's not yet defined, so I could not do it. But I had to define where to go. And according with the information we collect, the gravest crimes in our treaty jurisdiction were Colombia and Congo. In those days, 2003, 5,000 people killed in both countries. The difference was, in Colombia, they were doing national proceedings. My duty is not to intervene. And in fact, they continue doing proceedings, and in fact, showing the model, as much we asked questions, they did more proceedings. So basically that's the model. National system that's working. But in Congo, not. So we opened Congo. And we were discussing how to open Congo. I was asking my international relations advisor, how to open a case in this new environment. And she advised me, okay, you need to first discuss with other ambassadors to see if they support. When you get the support, then you go, and they will support you. But I say, what happens if they don't support us? Then, in this case, you cannot open. But we are not diplomats. We are prosecutors. So what you will do? I think we should go, and they should follow. And what happens if they follow? If they don't follow, we are alone. But we are prosecutors. It's not about popularity. We have to do it. So that's what we did in Congo. We informed publicly that we were going to open an investigation, but we invite the Congo to refer the case. And we managed that. But then this helped us to build how we contribute to the idea of peace. Because we understand our intervention should be managed. If I am in a national setting and I had to prosecute the top general of the country, I will inform the government to manage how to arrest the guy, because I like to avoid the coup d'etat. So I understand I had to be responsible, but it's not my responsibility. So what we did, two things, and that is the contribution of the Office of the Prosecutor to the peace process. First is a clear policy. We focus in those most responsible, no one else. So when the Security Council or someone refer a case to us, they know we'll do few cases against the most responsible. That's it. We are not, because complementarity system, the impunity for the others should be solved by the national setting, and will take time probably. It's not our business. So the first policy, very clear, focus investigation and few responsible. And the second policy is inform in advance. We always inform in advance what we'll do. We inform in all the cases, in particular the Security Council cases, we inform in advance. We present the case in Libya in 2 weeks. We present a case against Harun. No, we don't say the names, but we inform when we'll do the cases. So that are two things we do. Then for me, what is missing, and it's not a prosecutor responsibility, how we manage that. How you manage, okay, this is a country who is member of the treaty, or this is a country who the Security Council referred the case, how you manage that? And I think that is the part that this community here in API should start to debate and propose better alternatives. We have the good examples. I would suggest Kofi Annan in Kenya, masterpiece. He managed an impossible conflict. He put together two groups who were killing each other in a government. He convinced them to include in the agenda justice. And we should say that also, the Kenyan leaders were also masters managing this difficult situation where they worked together for the last 4 years now and keep moving, and even they accept justice should be done. I went to Kenya to inform President Kibaki. President Kibaki, as an independent part of the Kenyan system, I'd like to inform you, I should open an investigation into Kenya. If you like, you can refer the case to me, but if not, I will do it myself. And President Kibaki told me, Prosecutor, I will not refer the case to you, but I will support your independent activity. So we are working together, and Monday will be crucial decision. The judges will decide if the 6 suspects, the charges against the 6 suspects are confirmed or not. And that could be a crucial part. And whatever the court decides, I believe we're crucially important to help the Kenyans to have peaceful elections. They will decide who is the candidate. They will decide who is the winner. That is a Kenyan problem. But the international community will help them to establish very clearly whoever is competing cannot commit atrocities again. Committing violence to gain power is not a ticket for a cabinet. It's a ticket for the Hague. That's the message. And it's clear. Everyone understands. So I think Kofi Annan is a great example of someone managing, of course, it's Kofi Annan, but he managed so well, and we have to learn about that. How, for instance, he told me, you should stay there. For instance, when I saw the Ivory Coast crisis, you saw people coming and leaving, not helping. Kofi was always clear, you had to stay there, you had to find a moment to say, game over, it's your decision, and give the problem back to those responsible. But something incredible that Kofi did, he kept engaged. Kofi's still working on the peace process in Kenya. It's not about signing the peace process, it's to implement, which is the most difficult part. So I would suggest we have to learn more about what Kofi did in Kenya. And also, we can learn about the failures. No? We can learn about the failures. And we're discussing this with the UN, how we can learn about Uganda. It's interesting because, contrary to what public perception, the court intervention never destroyed the peace process. On the contrary, the court intervention were used by negotiators to start a peace process. When we intervene, when we start the investigation into Uganda, there was a peace process. Betty Bigombe, 2004, was running a peace process. In those that were doing the investigations, there was confidential information, no one knew what we were doing. I remember a conversation with a bishop, because it was a bishop in Uganda who said, look, my community want justice, please. You should come to my community. I said, Bishop, you made me very proud of my people because we were in your community, we took interviews, and you don't know. So we're really confidential, we keep, and then we never, Connie never discussed justice in 2004 peace process. However, what he did, when the peace process was advanced, he tried to kill Brigadier Kolo, who was the guy who was running the peace process. And the peace process collapsed. And when we were ready, it was like in 5-7 months after the peace process collapsed, we presented the case. And the Sudanese, they were afraid that we can prosecute Sudanese people involved with Connie. So they signed with us a peace agreement, an agreement of cooperation, committed to implement the arrest warrant. And this was one of the critical factors who pushed Connie outside of Sudan. He lost safe haven, and he moved to Garamba Park, giving a great opportunity to end him. But then the Juba talk started, and instead to stop Connie and arrest him, we let him do what he did 5 times before, cheat us. And he used the promise of peace to just make money, reorganize himself again, and attack again. 2,000 people were killed after. So I think it's a shame that we give him this opportunity. The Harun case is another case which you should learn, because we really miss an opportunity there. When we studied the Darfur case, we had a lot of information about Janjaweed militias, but people were not clear about how they were working. So my job was to try to focus on how the chain of command. And we found evidence, in particular information collected by Kasese, showing the minute of the security committees, that showing how was an absolutely hierarchical organization where security committees at the local level control the situation and define what to do. They report to state security committees, and these state security committees report to one person, Ahmed Harun. The chain of command was keep going up until the president of Bashir. But when we present the case, we have the formal chain of command. We have a lot of witness about Harun's role, how Harun was involved personally in recruiting, financing, and inciting Janjaweed militias. But we had not the same type of personal evidence against Bashir. So we decided to present the Harun case. And the Harun case was a great opportunity to stop the conflict, putting Harun in jail, and then no one else will follow illegal instructions. And in fact, what happened was a peace process started. African Union, UN peace process started with Eliasson and Salim Salem, but they did not include justice in the discussion. I remember there was a meeting here in UN with 18 countries, and the Sudanese ambassador in those days was outside in a press conference and was saying, justice? No one talked about justice in this meeting. The only one who talked about justice is Ocampo, but he's not here. So it's like justice was ignored and nothing happened. In fact, Bashir took, at the beginning for 3 months, when we presented indictment against Harun, Bashir organized a cabinet committee to analyze what to do, and he said no word against us. When he saw the soft approach, he went up, and Ban Ki-moon visited him, and 3 days after the visit of Ban Ki-moon in Khartoum, Bashir appointed Harun to be the chief of the investigation of human rights abuses in the North-South Sudan. Yes, look like a joke, but it's not a joke, because if you are a person who are killing civilians, and we know that your commander, Harun, is now the chief investigators, you know you can keep killing civilians, because nothing will happen. That's why arresting Harun and removing him was the strategy to stop the crimes. And even make a statement. I remember a conversation with the ambassador here about this, and I told him, look, Harun will give you an opportunity to make peace, but you have to force Bashir to arrest him and remove him. And the ambassador said to me, oh, it's a great idea, prosecutor. We cannot do it. Why not? Because we don't know how to do that. We have 2 strategies. We threat with bombing, and we have to be ready to bomb if they are not doing nothing. But as soon as they start to negotiate, we do nothing. Between bombing and nothing, we have no strategy. In those days, I was laughing, as some of you are laughing, because I was thinking it's a joke. I'm sorry, it's sad. It's not a joke. That's the current status of the affairs in negotiation. We threat, and some people believe we threat with the ICC now, the prosecutor will prosecute you. As soon as they say they will negotiate, we try to stop. And then, because we cannot stop, they say, oh, the prosecutor is responsible for this. But the problem is, such a primitive model was an idea 100 years ago, but not for today. Today the rule is, no leader in power can commit massive atrocities and remain in power. And the problem is, if you are Gaddafi and you spend 40 years torturing people and killing people to stay in power, you cannot remain in power, stop being democratic and remain in power. That's why it's not naivete. Naivete think that you can negotiate with a massive killer and then he will become a good, decent, democratic elected president. It will be no democracy. So if Gaddafi stay in power today, imagine Libya today. So that for me is the missing point. It's not a court intervention blind. It's the court is showing first what happened with the victims that normally was ignored and now cannot be more ignored. And the court is showing how the state works. The Darfur genocide is not the result of tribal debates. It's a deliberate policy, strategy implemented by the forces and adopted by Bashir. So all the rest are the consequence of that. If you have problem of access of humanitarian assistance, it's because Bashir don't like that. So it's not a marginal issue, it's a central issue. So the concept for me is, when in a case you have like a minister like Harun indicted, you need a strategy how to negotiate with the head of state to marginalize someone very important. But if you have a different guy like Bashir indicted, okay, you also need a new strategy, how to manage the situation, to isolate and remove. And I saw that in my experience in the Bashir case. When I present the Bashir case was the last 6 months of President Bush. And the special envoy told me, look, President Bush, as you know, don't like this court. But he was totally committed with the Darfur issue, so he will be tough on this. And he publicly said that he will veto any attempt to stop the investigation. And I saw the world changing and adjusting to that. Some big countries telling me, you know, prosecutor, we are deeply involved in Sudan, we believe that Bashir's stability, but now with Bush so strong, what is the exit for Bashir? So people were discussing. I have information how some leaders inside Sudan were very tough with Bashir. But then, difficult geopolitical situation, next year, situation changed, the pressure was gone, and nothing happened. And Bashir is now doing the south what happened in Darfur. And we are not talking about that because we're happy that the South is independent. But it's a shame. We have a genocide ongoing in Darfur, and nothing happened. We have a serious allegation of crime, nothing happened. We don't know how to manage that. And it's the consequence of the previous mistake. But going back to the idea that prosecutor is not affecting peace processes is, as I said before, after we launched Harun case, Eliasson, Salim Salem process started. I announced at the beginning of June my next case against the person who gave instruction to Harun in the Security Council, June 8, 2008. And on the 20th of 2008, June 2008, Salim Salem and Eliasson resigned it. So they resigned it before I presented my Bashir case. I presented the Bashir case, and a new process started with Qatar and Basoleh representing UN African Union. So the peace process were not cut by, on the contrary, we create opportunities, but how to take opportunities is the missing part. And I like to finish my presentation insisting on that point. The prosecutors cannot adjust to the political consideration. We could not decide when the negotiators say, okay, now it's better to stop, I stop, go ahead. Because then I have no money to that. And I will destroy the office of the prosecutor and the court if people perceive the court just adjusting to political consideration. So the court is a court, and the court has to know that. And when the Security Council refer a case to the court, they have to know. Before you refer the case, yes, you can bluff, you can threat, you can say, the court, if you are not doing this or that, will refer the case to the court. After the referral is done, judicial time, then you still have the Article 16, but be prepared to do it. So, and for me, this is basic, but sometimes when you read the newspaper, you're confused. As you say, people blame me for problems where, in fact, factually are wrong, but also it's not my responsibility. But then we have to go back, how we can manage better the negotiations. That is a real issue for people like you. And I'm very pleased I had this opportunity to meet with you. Thank you very much.
Let me thank the prosecutor for this lucid and illuminating discourse. I need you to help to send some of these ideas to the leaders of the Arab Spring countries, because I don't think they get it. I think this idea that a crime committed against one-ounce people is a crime against the international community, not only against a particular minority or a civilian population. And I think this idea that there is now a consensus in the international community that a ruler who commits crime is no longer qualified to rule his people. And this is very important. But mind you, in the case of Libya or in Syria or in Yemen, it is not the international community or even the Security Council, it's the people of those areas who made them unqualified to continue to rule. Perhaps because there is this idea that sometimes justice and peace do not converge, they diverge. And for prudence, you give peace precedence over justice. This is sometimes the case. I think what is important, and I take your point, the Security Council, whenever they refer cases to the court, they must realize that the International Criminal Court is a legal, not a political instrument, and it must be respected and must be enhanced in that case. With this, I'm going to open the floor for people to comment or speak their views to the issues. And you will be given a microphone, and please keep the microphone close to you so we can hear you very clearly. The floor is open. Peter.
Thank you, Peter Gastro from the IPI. I agree entirely with the approach and makes sense. Your task is prosecuting, pursuing justice. You cannot be diverted or influenced by the considerations which relate to peace. But I'm still interested in this tension which must on occasion arrive. Hypothetical case. You are prosecuting already a high-profile leader in a fragile state, in a difficult environment, and many of the cases are in fragile states. It's clear to commentators, and you quietly accept it as well, that the conviction of this person may well lead to a civil war in that country. There's this tension now. Your task, clearly, as you say, is to continue with the prosecution. You cannot allow yourself to be deflected by that. But who is going to look at the peace aspects and whose responsibility is it? I'm asking you now, not as prosecutor, just as because you can't, it's not your job. But I was wondering who does that and how does that work? Because you can have serious tensions really leading really to a downhill situation. Thank you.
But it isn't the case. Bashir case was that case. Bashir case was clearly that case. And for me, at the beginning, I remember when I received the referral, someone told me, look, be careful, because at the end, I start. Not working? I start again. I remember when we received the Bashir, the Darfur case, someone say, it's a gift, it's a poison gift. It's a poison gift. You will be, gift, you will be irrelevant. And I remember I had to investigate a difficult crime. We decided not to go to Darfur, and we took 21 months to present our case. And many friends from the NGO were furious with me because where is your case? Why you are not doing the case? So we collect the evidence, and we're very proud that we found Harun and described the chain of command. And then we're thinking, okay, we did our job. Now the diplomat will fix it. And then I found it was disaster. And then that was my next challenge. We keep collecting evidence, and President Bashir started to say, I will not hand over Harun because I was giving instruction to him. He was following orders, he said. And that was my dilemma. Okay, now I learn, if I present the Bashir case, my court will be isolated. But if I don't present my Bashir case, the victims will be ignored. And the court also will be destroyed, because I know international community now, 5 years later, we say, prosecutor, how you ignore a genocide in Darfur? You're stupid. So, again, my duty is to prosecute the crimes and to show the crimes. And what I did, December 2007, June 2008, I informed what I will do. I give enough time to the Security Council to think in advance on that. I will repeat the story because it's a true story showing the problem. I remember, as I said, December 2007, June 2008, I informed the Security Council. I will investigate that in December. In June, I say, I will present my case in July. And in July, I present my case publicly. And in September, I have a meeting in New York with an ambassador who told me, furious, prosecutor, how you can indict the head of state without informing us in advance? I say, ambassador, I was on the record saying I will do it. And the ambassador say, yes, you say that, but would not believe you will do it. So I think now they believe we'll do it. And in some sense, we have to take lessons. But going back to your questions, I understand stability is important. But you know the battered woman syndrome? The women who are beaten and they believe, oh, I forgive my husband, will be nice tomorrow. The victims in Darfur don't have it. The victims in Darfur, those who were exposed, they like it and still like the indictment. The negotiators have the syndrome. They believe Bashir committed genocide yesterday, but maybe tomorrow, no. You know, genocide is strategic, requires strategic planning. It's not easy to change. So, of course, instability creates problems, but the stability of genocide is worse. And my job was investigate the crimes and present it. And I had to keep in my own area. It's not working well. I deeply regret. Each night, I think what else I can do for Darfur people. But I cannot change my duties or invade the duties of others. That's why I think it's a great opportunity to be here, to discuss with people like you, how we can do it better. Because we need to do it better. People in Darfur need you.
Thank you, my friend over there.
It's working?
Yeah, I think so. I think I want to vote on this case.
Okay.
Go ahead. Go ahead.
Thank you, Mr. Prosecutor. My name is Steve Lamonet from the CICC. I have two questions. I just wanted to know from you what plans you have in case the charges are confirmed against the suspects in Kenya to disseminate information and explain to the ordinary citizens what that means for them. Secondly, on your strategy to isolate and remove, I just wanted to hear from you if you're having these discussions beyond Darfur. For example, in the scenario again like Kenya, if the charges are confirmed against the 6 or in another scenario if they're not confirmed against some of the suspects. Thank you.
Thank you. My friend here.
Mr. Moreno-Ocampo, Jeff Laurenti with the Century Foundation. Let me ask, not broad principle, but rather narrow kind of history. Without much access on the ground in most of Libya, what kinds of information and sources were you able to amass that led to the effective indictments against Gaddafi and sons? And was it more of a political judgment than an abstract judicial one to acquiesce in letting the Libyan factions keep Saif al-Islam Gaddafi to handle it on that end? And more broadly, when do you think the Security Council will be prepared to take measures to ensure that ICC determinations are implemented?
My friend over here.
Bill Pace, and I'm here on behalf of my peace organization, the World Federalist Movement. And I just would want to say thanks to IPI. This is and the prosecutor. This is a tremendous, I think, presentation. There's a lot of sentimentality for me here. I had offices on the 12th floor for 30-some years. This is also where my organization helped start the International Peace Academy back in the early 1970s. And this is where we began our first meeting of the Coalition for the International Criminal Court that helped contribute to that, and where Luis Moreno-Ocampo and I had our first meeting in 2003. And I just wanted to indicate that I do think it's important that what has happened in the last 16 years with international justice is one of the greatest achievements in trying to achieve the first preambular goal of the UN Charter in its entire 66 years. And the ICC is the centerpiece now of that achievement. My real, and that the Prosecutor Moreno-Ocampo, as a primary leader of the court, has a tremendous amount, I think, to be proud of as he finishes his term in June. I want to say that in addition to the gray and the blue, our goal is to get universal ratification eventually, and the fact that you can hardly produce one of these programs without it being out of date within a matter of 1 or 2 months with new ratifications, new developments, is a very significant effort. The second point, and we do have 120, and we were not expected to ever get this court, much less to get 60 ratifications, so I think that's important to keep and remember. Secondly, the selectivity of the Security Council is an important issue that needs to be addressed. It's not the International Criminal Court that is selective when the council refers its selective cases to it. It's the council that is being selective. And I want to say that one of the hypocrisies is that many of the governments that criticize the selectivity of the Security Council themselves would not want the Security Council not to be selective. They would fiercely oppose a consistent policy, though I think NGOs will continue to work for the kinds of reforms of the Council and its working methods so that it would become more consistent in the future. Thank you.
2 more speakers, then I will give the floor to the prosecutor. The lady first. and then we will have another round.
Thank you very much. I have two brief questions. The first is on Kenya. You mentioned earlier about sort of targeting the people who are at the very top, who are responsible. So in the Kenya case, when you have the head of the public service and the head of the police, I'm just wondering how the public service is not the responsibility, or that the principals, I guess, in the negotiations were not involved, and what you can comment about that. The second is what the lessons learned from the Kaliste Mbarashimana case are, being that his case, I guess, did not make it right through to trial. Thanks.
Floor here.
What's the next question?
Yeah, I'm Richard Dicker from Human Rights Watch. Prosecutor, question
Bring
for
the
you.
micro closer.
Yeah, question for you. Having observed the two referrals by the Security Council, as difficult as those have been, what seems more difficult is the Council committing itself to supporting the referral that they made to your office through ongoing diplomatic and political expressions of support for the arrest warrants the judges issue in response to your requests. And I see that as a very damaging failing by the council and council members, in particular because it does feed the argument, which I think is incorrect, that the court is just a political tool used by great powers. I don't accept that argument, but I think the failure by the council to provide the diplomatic backup that you need is quite harmful to the legitimacy of the court. I'm wondering what perception you have of that phenomena, or if you see it at all. Thank you.
Thank you. Welcome.
Okay. You were asking me about the evidence in the Libya case. Today, Jose was presenting a very nice point. He said, if someone is acquitted in court, for the prosecutor is a failure, but the judges will consider proper, because they consider should be acquitted and be perfect. And it's true in terms of individual criminal responsibility. But imagine if we arrest Bashir, we put him in court, and then no good evidence, and he's acquitted. And was, oh, I'm so sorry, President, was not genocide, go back. It's a disaster. So I remember a meeting with the Minister of Foreign Affairs in Europe when the judges stayed the proceedings in Lubanga. And Minister told me, Prosecutor, how did that happen? We make so many efforts, so much efforts to put this guy in jail, and now you acquit him. Impossible. So the judge have the responsibility to acquit when it's proper. But I had to be a good prosecutor, be sure when we present the case, I have the evidence to win my cases. So I never in my life will present the case with no evidence. I cannot do that. So how we got evidence in Libya and in Darfur, we learned how to do it. Darfur helped us to learn how to collect evidence without visiting the place. But in fact, in Libya it was easy because there were many people who escaped. There are many friends. We collect a lot of details about a meeting between Muammar Gaddafi and Saif Gaddafi and al-Sanusi, how they planned the crimes. We collect details how Saif personally was involved in hiring planes to move mercenaries because they would not trust the Libyan forces. So we have all the videos about the shootings on the streets. So it was easy to prove the individual incident, and we have high-level people who were able to tell us stories. And in fact, to avoid security problems, I did not allow my investigator to go to Libya. But what happened, we started to receive phone calls from Libya and generals talking to us because they want to be clear what they are not doing. So at the end, was not so difficult. We could do it. But as a concept, because we cannot fail, we never present the case with no evidence. And it's funny, I remember there was a debate. We met 5 years ago in Arusha, international prosecutor, to discuss strategies. And the new Rwanda prosecutor, Hassan Jallow, explained the new strategy, 1.9, 2, 3, and the 3 was, we are not presenting cases, we have no enough evidence. And I say, okay, it's a good policy, but what was the previous policy? And it was fun because one of them explained, and that's why I like to learn from the mistakes. He said, it's true. What do you do? Cameroon call us and say, we have the former Prime Minister of Rwanda, is here, we can arrest him tomorrow. What do we do? And so we're not ready, we have no case, but we cannot miss the opportunity. So they jump on it. And that is something, in particular, ad hoc tribunals have the problem. I remember discussing with David Crane, why, because he always explained to me that he was trying to respect African leaders, but he destroyed the African Union meeting to solve the Charles Taylor problem. He had no time. So one of the good things of the permanent court is the court has to be a court. We have no evidence, no case. But when we have a case, we have the evidence. Your question on the Security Council implementing arrest warrant is similar to the Richard Dicker question. And then let me answer both at the same time. In fact, today, in the morning conversation, one of the members of the conversation was something very interesting. He put it on the other side. In fact, what happened is ICC is providing energy to Security Council. Now Security Council has much more power than before because sanctions are not very great threat. And war is a threat, but it's not difficult. Now, arrest warrant is a great threat. So in fact, we are providing this, and they are still learning how to do it. I agree we can do better, and we should explore how to do it better. But that requires not just Security Council imagination. I am thrilled. I don't know if you know what's happening with Joseph Kony. Joseph Kony is at large, committing crimes. And Congo or Central African Republic had not the ability to capture him. And a group of 25 years old from San Diego, California, called Invisible Children, they mobilized 3,000 kids of 18, 20 years old to lobby the US Congress. They passed a law, Obama signed it, and now they have 100 soldiers, US, advising and behind the troops to arrest Joseph Kony. So that's what we need. We need similar active people with similar kind of capacity to overcome problems to find new solutions. The Security Council will not change itself. The Security Council is comfortable, they have their own rules, their own views. We have to invent something and mobilize them. Of course they need to do more, and it will be great to focus what else we can do on Bashir. It's a time to decide something different on Bashir. So I agree, we should do more. Don't just criticize Security Council. Help them to think better. Then, on the issue of universal ratification, when I agree, one day the court should be universal. It will take time. Because, for instance, proposing Yemen, your country, to the current president, still current president, no? If he wants to ratify a treaty. In fact, he was saying he will ratify a treaty, but apparently he's not always saying the truth. And he has no incentive to ratify a treaty. If you commit crimes, you don't like to do it. That's why in Africa, there are more than 30 countries who are supporting, but there are other countries who are not supporting because there are still countries in Africa who the leaders are committing crimes. So there are some countries who have no interest to do it. There are other countries who are so big that they believe they can protect themselves with their own armies, and also they don't like the idea to have a prosecutor on top of them. And so there are constraints, and I think we'll be careful. A country who's inside the ICC should be really committed with the idea that there will be no impunity. If we just let them sign the treaty and no one follow, it's problematic. So I think universal ratification is good, will happen, will take 40 years probably, will take time, and it's okay. In the meantime, on this selectivity of Security Council reforms, Security Council, I don't know, I think it was a good idea to refer to Libya. And I respect that they are not referring Syria, because I see they have different options and different problems. Also the resolution 973 divided the Security Council, so there are problems. I can understand them because it's not easy to change. So selectivity is normal in Security Council, should not be selectivity in the Rome Treaty system. And that we have to understand and explain better. Let me go to Kenya. First, basically you are telling me why not Kibaki, why not Odinga? Because you know what? I'm not doing political analysis. I'm following the evidence. And the evidence never showed me Kibaki or Odinga involved in the crimes. They were involved in the group who committed crimes? Absolutely, they were the leaders. I have any information that they were involved in planning, organizing, financing the crimes? Zero. And in fact, when Mr. Kenyatta said that in court, that Odinga should be prosecuted, I asked him, do you have any information that he was involved in the crimes? No. It's a political claim, not a criminal case. And I'm sorry, I follow evidence. I'm a criminal prosecutor. I'm not a political analyst. So maybe you don't like it, but I will not prosecute people for political reasons. Okay? But Oshimana lesson learned is that I believe the chamber made a mistake. It's a lesson learned. And I appeal, and I think I will. And I think Baruchiman is a fantastic case where the person who we are prosecuting is not the guy who gave the instructions. It's the guy who's doing the cover-up. It's the Goebbels of the organization. And it's a split decision. It's majority and minority. The minority understood very well the case. The majority did not. So the lesson learned, we appeal, and we try to explain very well why he's responsible. And I think we'll win. Same thing happened with Bashir. We lost the genocide charge first, and then we won. And Kenya. On Monday will be a decision on Kenya. And I think Kenya is a fantastic example how a country is managing difficult conflict. Imagine a country in which we are prosecuting the deputy prime minister, who's also the candidate to be the president, the main responsible of the government, and the leader of the opposition. And it's working. And they went to the court, and they are respecting the court. What I expect from Monday? I expect most of the cases will be confirmed. And I expect will be discussion in Kenya, but no violence in Kenya. And probably expect that they will do a lot of legal challenges after, because they want to run for elections. So I expect also that is they can have different type of legal challenge to postpone any trial, and in the meantime try to be elected, and if they are president, they believe they will escape. That's okay. But in some way, if this happens, it's okay, because Kenyan should define the future. No international organization can solve Kenya. So we can make some activities there, but at the end, who is the president in Kenya and who is voted is a Kenyan business, not my business. So will be combination. I suppose the judge will confirm it. I hope we can go to trial very soon. I see they will probably use litigation to delay, and that's the future I see. How to explain that in Kenya? I'm sorry, in Kenya, the best people in Kenya are knowing exactly what's happening. For me, it's difficult to measure how people understand the process. But one measure we had in the past is that they have one of the best political analysis is done in a puppet show. In Kenya, it's a very funny puppet show they have. And Ocampo became one of the puppets. But it's normal because I was there. But the most interesting thing is, a new puppet a few months ago is Judge Trandafilova. The judge is a puppet. And so and she never make any statement outside the court. But with the courts in function, they see what happened. And the information I have is, one of them was telling me, you're not prosecutor for me? When I see Mr. Kenyatta answering, my name is Mr. Romo Kenyatta, and this is my occupation. This man, the most powerful man in the country, giving explanation to the judge, that's a dream. So that's what the court is doing, and I believe in that. You know, sometimes jokes at me because they charge me that I'm not explaining well my cases, that's why people in the countries are attacking me. And I try to explain, look, in Argentina, when I was a prosecutor, I was going to lunch when we went to my mother's house, explained to her what I was investigating, and she was thinking I was wrong. She was thinking General Videla was a nice man. She was in the church with him, and she reminded his father was a general too, so my grandfather was a general, so my mother loved General Videla. So I could not convince my mother. The trial convinced her. When the trial started, my mother called me and said, after 2 weeks, she said, I still love General Videla, but you're right, he has to be in jail. And in some way, I see that in Kenya. In Kenya, that is happening. The hearings, the respect that the hearings show is transforming Kenya. And I hope, I'm pretty sure, I don't know when we'll have a trial, but I'm pretty sure the next election will be a peaceful election. And that's a huge contribution to the country.
Thank you. Ambassador Hirsch.
First of all, thank you very much for everything you've been doing, as well as for your presentation here. I want to ask you two very short questions. One is what you want member states to do with regard to the arrest of President Bashir. They're not doing. I'm thinking of the fact that he was at the inauguration of Salva Kiir, and the Secretary General of the United Nations was there as well as all kinds of other leaders. And of course, he was not arrested. This is what happened with Taylor when he went to Accra. So what is it that you think the member state, you've said generally they should do better, but what does that mean? Secondly, as you know, there's this criticism that all the cases are African cases. And in the video that was shown before you spoke, you showed 8 or 10 potential cases that are not in Africa. Do you expect any of those cases to come forward with a specific prosecution before you step down at the end of your term? And which ones, if you might say?
Okay.
Does anyone else want to take the floor? I think you can.
Okay, you are turning to me the question I made to you. What else you can do to arrest Bashir? I don't know. I was never a diplomat, as you see. But what I saw is when the Security Council member in agreement, they do whatever they want. They really change everything. So I would suggest, but then you need leadership. I saw that in a few months, during the last 6 months of Bush administration, that Bush was really pushing. He changed the dynamic. I suppose we had to find a way to reach consensus in the world that this could not happen. Bashir committed genocide in Darfur and is committing massive atrocities in the south. This could not happen. Something should change. And I suppose that if the states agree on that, they will change. That is what I can say from outside. I cannot, you probably know more than me what you can do. On the issue that my cases are in Africa, as a prosecutor of the court, first, the big difference between Nuremberg, Yugoslavia, and Rwanda is that the situations in these 3 previous ad hoc tribunals were selected by the Security Council. So the decision where to do justice was selected by the Security Council. And that was the idea of, in particular, the Clinton administration with the ICC. Security Council, or eventually the states, will define where the court go, not the court independently. Because this was not adopted, was the prosecutor and the judges deciding. That was a huge problem. And so what I did is follow, there are 4 criteria in the statute. One is crimes under my jurisdiction, okay? Could not be aggression, should be crimes against humanity, or crime of genocide. Second, not national proceedings. As soon as there are genuine national proceedings, like in Colombia, I'm not delaying Colombia. I'm following what Colombia is doing. The president of Colombia asked me, prosecutor, how you can be out of your list? Because my country is a big country, we don't like to be there. And so, okay, ICC, stop all the crimes and prosecute all the leaders, that's it. He's trying. He said, I'm trying, but yet, and you see, as I say, there were 5,000 killings in 2003, now it's 200, 300, so it's a drastic reduction, and there are many cases, but still there are cases. And so that's why I'm not delaying Colombia, I'm just respecting national investigation and prosecutions. So that's the second criteria. Then gravity. Gravity is not clear defined, but we started in Congo, we have 5,000 killings. In Uganda, we have 2,300 killings. Then Darfur was higher. Then Central African Republic have not so many killings, but had hundreds of rapes and lootings. Then you have Kenya with around 1,300 people killed, 400,000 people displaced, and I suppose more than 5,000 women raped. And then you have Libya with massive attacks against civilians in the squares, at least hundreds of people killed, and massive attacks of abducting and torturing people in Tripoli in particular. And then you have Cote d'Ivoire, with again around 1,500 people killed and many rapes. These are my cases. Gravity is okay. It's not frivolous case in the dock. And then interest of justice, we believe all the cases should be prosecuted, so it's okay. So these are the criteria. Should be I evaluated because I have no women in my dock? No, because gender representation is not a criterion. Geographical balance is not a criterion, because in fact, the court would be perfect if there were no case. So this is a case of last resort, the complementarity court, so we should not take this into consideration. That's why it's a frivolous request that I have cases in other continents, because it's irrelevant. If the court was created in the 40s, the court would have cases in Europe. If the court was created in the 70s, we have cases in Latin America. A court created in 2003, we have the cases in Africa, because 70% of the issues presented before the Security Council are from Africa. And in addition to that, you have Sri Lanka, Lebanon, Iraq, who are not the parties. So I'm doing the case I have to do. This issue of Africa is an alibi developed by Bashir and Gaddafi, who hate each other but protect each other against the court. For me, it's something in the New York. One of my biggest problems in terms of communication is when a particular tribe, the New York tribe, that's why I'm very happy to be in the House, because sometimes you have these ideas and then you spread the ideas and it's impossible. I think it's completely frivolous comment. The idea has to be outside Africa. But even NGO follow that. I remember 2 years ago we have a meeting and I received a formal request not to open cases in Africa. But then I opened Kenya. Yes, Kenya is very good. Then Libya come. What I should do? Yes. Cote d'Ivoire? Yes. So I keep opening cases in Africa because it's my duty, and they keep repeating I should not do more cases in Africa. I'm sorry. I do the case in accordance with the law, and that's what I do. I'm not here to receive claps.
And these 8 or 10 that were shown in the video?
That's exactly the work we do, because my duty is first to prosecute cases before the court, investigate before, but the first is what the Rome Statute called preliminary examination. We collect information to define these 4 criteria I mentioned: the jurisdiction, the admissibility, the gravity, and the interest of justice. So these 8 situations are under consideration. But it's not I should not open Colombia. So there are 3 of them, Colombia, Guinea, and Georgia, where there are proceedings. We are considering if they are proceedings genuine or not. So, and it's my duty to respect complementarity. In fact, should be interesting to see when I was taking office, people were saying, oh, you are a frivolous prosecutor invading national state. In fact, or not respecting complementarity. I opened 7 situations. In all these situations was no case. In all the situations I opened investigation was 0 case. And we are analyzing well Georgia, Colombia, and Guinea, where there are cases. So this is my duty. So what I do is apply the law. But of course, it's not preventing that people have different opinions.
Thank you. We will have time for one more question and then we close. Warren, please.
Warren Hogue, IPI. Prosecutor, we like to think that a Hama could never happen again because, as you said, we're now in the world of Facebook. Hama happened almost secretly. The press knew nothing about it. We still don't really know the actual numbers, the tens of thousands who were massacred there. My question to you is, I hope it's true that it's much harder now to commit atrocities that the world is watching. Clearly, in the case of Syria right now, you have it. That evidence is very persuasive in the court of world opinion. My question to you is, will that kind of evidence be evidence you can present to a court? Will it be easier for you as the prosecutor to prove atrocities now that you have so much visual and audio evidence that it took place?
For instance, in Libya, we have a lot of videos, but we don't know if they're authentic or not, so we're not using as evidence. But in fact, when you commit such massive atrocities, you don't need this. You can prove the case always. It's difficult to hide. But for me, what happened is, we're used to the idea, and you were in New York Times, so you know that when information in New York Times, oh, something will happen, because there's a government here who is in charge of peace and security and justice, so they will take action. But it's not true in the world. Information is there, and then nothing happens, and then disappear. Information is not enough. Darfur is the best example. We're worried about that for a while. We have an arrest warrant issued by 5 judges saying it's a genocide, and nothing happened. So I say, what I say is not that it's finished. Crimes are still committed. Those committing crimes are still managing power. And we are not very efficient to stop them. We don't accept that this is good, but we are not very efficient, and we are trying to learn how to do it. So that's my point. The point would never be, answering better your question is, I don't see it will be a problem to have the evidence for the cases, but maybe the case never reached the court. The issue is how we stop the crimes now. That's the issue. Not the issue, because imagine if you are in Darfur, and you see, okay, the world know everything about us, and they are doing nothing. I don't know if you saw Darfur now. There is a sheikh who is filmed, and the guy is showing the difficulty he has and the hope he has in the court. And there's a footage we not show, because the sheikh who was in charge of the camp had a commitment that there will be no weapons there. And one young member of the full community has a Kalashnikov. So he had to make the difficult decision to deliver the guy to the security forces, knowing that probably he would kill. And they filmed this. This sheikh was killed 3 months ago because he was running this camp very well and he was opposing to be dismantled. And then they killed him. No one cared. No one is doing something for them. So that is a reality. That's why, yes, we have an intellectual and challenging task, but in the meantime, each day we are not facing it. Some people are dying. And that's why it's important to do something. And that's why I'm very glad to be here.
This has been extremely fascinating session. And I think you all agree with me that Prosecutor Ocampo has provided a lot of food for thought. But I want to conclude by, on behalf of you, expressing our appreciation to you for your work, excellent work as a prosecutor of the International Criminal Court. Thank you very much.